Good morning and welcome to Pepperdine Law School. My name is Bob Cochran. I'm glad you could be with us. I'm pleased to see that we have wonderful weather for you. As you can see, as you look out the back porch of Pepperdine when you get a chance. The pictures on the posters really are real. They really do portray how pretty it is here at Pepperdine. One of our members of our Board of Visitors is Judge Tom Reevely of the Fifth Circuit Court of Appeals, and his comment about Pepperdine was that it's the kind of place God would build if he had the money. But actually, we thank him for providing us such a beautiful day for you all to be with us, especially those who have come from the Northeast or the Midwest or various other climates that are experiencing sub-zero weather these days. Well, our schedule says that we're to be greeted by our dean, Ken Starr, but we're not going to be greeted by him right now. He's going to actually be speaking on one of the panels later on in the day, substituting for one of the speakers that could not come, and he'll have the opportunity to greet you at that time. And what we're going to do is to just go ahead and jump into our first panel. Our moderator is Professor Barry McDonald of Pepperdine. He's a Northwestern Law School graduate, clerked for Justice Rehnquist. He teaches contracts, constitutional law, and he specializes in science and the law, and in particular in the First Amendment. Last year he directed a groundbreaking conference that we had on the First Amendment, so he was sort of in my shoes at that time, and it was a wonderful conference. He has a forthcoming article on the area of religion and science in the public schools, and he'll be introducing our first speakers. As you may have noticed from the structure of the program, we're sort of starting off broad, considering the whole area of religious liberty and how it might apply. Generally, we may get into a whole variety of topics. And then as the day goes on, we're going to narrow and we'll focus particularly on the church property disputes. Just one word about the way that I've got the room set up and also the way that we'll be handling the questioning. Our speakers for the day and moderators are seated about halfway back to my left. And we're going to begin the questioning following people's, the panel presentations by giving them the opportunity to speak and comment and raise questions of the panelists. And then we'll broaden it out and give all of us a chance to raise questions. So let me introduce Barry McDonald.
Well, thank you, Bob, and thank you for this opportunity to moderate a panel with such distinguished religious liberty scholars and on such an important topic as the state of religious liberty in the United States. Well, what is the state of religious liberty in America? Well, our distinguished experts will be telling us all what it is. But if you were to ask the ordinary observer, and I include myself in that group, compared to many countries in the world where religion is either still forbidden, dictated, or merely tolerated by the state, I think you'd have to admit that it seems pretty strong and healthy here in this country. We have rights of religious liberty embodied in our federal and state constitutions. We have many federal and state laws that support the exercise of those rights. And we have strong social and cultural mores supporting religious institutions and activities in this country. And yet we definitely have our challenges as well. Let me briefly mention just one major area of dispute that's been at the forefront of recent events here, in particular here in California. They tell me you're supposed to be provocative, especially early in the morning, to wake you up, and so I'll try to be as provocative as I can here. Right now, somewhat ironically, we have two different activities or statuses that are protected by anti-discrimination laws that are on a collision course, religious belief and sexual orientation. Obviously, those that believe homosexual behavior is contrary to their religious beliefs believe the increasing expansion of anti-discrimination laws and norms threatens their ability to believe that gay conduct is wrong and embody that belief in what they're able to say and do. Not only are religious groups worried that they will eventually have to perform same-sex marriages against their beliefs, and are currently being subjected to what I think is fair to say McCarthy-like tactics when you're posting maps of Google with donors' names and addresses on the internet for those who supported Proposition 8. I think, either rightfully or wrongfully, they, in good faith, believed that that proposition was addressing their concerns about this eventuation of perhaps having to perform same-sex marriages against their beliefs. And marriages is not the only area where similar concerns or worries about the future are manifesting themselves to this group. For example, in the North Coast ruling that was recently handed down by the California Supreme Court, the court almost dismissively dealt with a claim that a doctor's right to religious freedom allowed her not to inseminate a lesbian woman. And the court dismissed the claim on the basis of the Smith ruling, and I wonder what Justice Scalia would have thought about Smith being applied in that way. Of course, there's the issue of whether religious charities must employ openly gay individuals against their wishes. There's the issue of whether hate speech laws may eventually be applied to those that preach against homosexual conduct in the pulpits. And indeed, there's the issue of whether churches themselves may eventually be forced to openly accept gay pastors, bishops, and other leaders against their wishes. Indeed, a concern that is leading to the church rifts that form the main subject of this conference today. Well, on the other side of that debate, however, the gay community is concerned that its own religious liberties are being threatened. They would argue that they're entitled to government and basic public services, such as health, education, and even civil marriage, that does not impose religious beliefs and values of others upon them. Indeed, they would point to a new California Court of Appeals decision holding that a private religious school could expel 2 teenagers who were allegedly lesbians as being wrong. They would point to the fact that this school presumably receives tax and other benefits from the government, which should not be used either directly or indirectly in a way that treats them like misfit citizens. They might even argue that this treatment violates most religious precepts. Well, as I said, this is just one major area where people claim their religious liberties are being threatened, but there are a whole host of more. And thankfully, we have our panel of experts here to help guide us through these extremely nettlesome issues and to assist us in thinking about them. We are very fortunate then to have them with us today. Our first speaker will be Professor Alan Brownstein, who will discuss the current state of our religious liberty from both a constitutional and cultural perspective. Professor Brownstein is the Buchiver and Bird Chair for the Study and Teaching of Freedom and Equality at the University of California, Davis Law School. He is a nationally recognized constitutional law scholar and focuses primarily on church-state issues and free exercise and Establishment Clause doctrine. His articles have been published in numerous academic journals, including the Stanford Law Review, the Cornell Law Review, and Constitutional Commentaries. He is also the editor of The Establishment of the Religion Clause, its constitutional history and the contemporary debate, the first volume of a series of anthologies on the Bill of Rights that were published by Prometheus Books. Professor Brownstein has testified on several occasions before various California Senate committees on legislation promoting religious liberty and bills that raise Establishment Clause concerns. After Professor Brownstein, we'll have Professor Leslie Griffin, who is the Larry and Joanne Doherty Chair in Legal Ethics at the University of Houston Law Center and teaches constitutional law and torts as well as legal ethics. She is the author most recently of Law and Religion, Cases and Materials, published by Foundation Press in 2007, which combines her academic interests in both law and religion. Professor Griffin holds a PhD in religious studies from Yale University and a JD from Stanford Law School. Prior to joining the University of Houston faculty, she clerked for the Honorable Mary M. Schroeder of the U.S. Ninth Circuit Court of Appeals and was an assistant counsel in the Department of Justice's Office of Professional Responsibility, which investigates professional misconduct by federal prosecutors. Professor Griffin was also elected to the American Law Institute in 2002. And last but certainly not least, Professor Steve Smith, given his law and philosophy orientation, will reflect on what we should think about all of these complex issues. Professor Smith is the Warren Distinguished Professor of Law at the University of San Diego. He is one of the nation's most foremost scholars in the area of law and religion and teaches in the areas of law and religion and constitutional law. Before joining the USD Law faculty in 2002, he was the Robert and Marion Short Professor of Law at the University of Notre Dame and was previously the Byron R. White Professor of Law at the University of Colorado. Among his many scholarly works are The Constitution and the Pride of Reason, Foreordained Failure, The Quest for a Constitutional Principle of Religious Freedom, and of course, one of his latest books, which was the subject of a symposium that we held here last year called Law's Quandary. Professor Smith's articles on law and religion and constitutional law have been widely published in prominent journals such as the Yale Law Journal and the Michigan Law Review. Well, please join me in welcoming our distinguished panel of specialists here and welcoming Professor Brownstein to the stand.
Thank you, Barry, and I want to thank Bob Cochran and Pepperdine Law School for inviting me to today's conference. The subject of our panel is the state of religious liberty in the United States. As Barry said, I'm going to talk generally and fairly abstractly about religious liberty from a constitutional and a cultural perspective. Let me begin by providing a broad overview of the place of religion in constitutional doctrine today. I have four basic observations. First, I think it's fair to say that religion has a limited and diminishing role to play today in the constitutional scheme of things. If we look at free exercise and Establishment Clause cases over the last 2 decades, it seems clear that the courts are deconstitutionalizing religion by reducing the scope and rigor of both clauses. The resolution of church-state issues are increasingly being relegated to the political branches of government. The court stated this explicitly in Employment Division versus Smith, when it held that religious individuals and institutions receive no constitutional protection against neutral laws of general applicability. Creating religious exemptions and accommodations, the court emphasized, was the legislature's job, not the court's. The Establishment Clause is also shrinking. It is far less of a barrier to government aid to religious institutions today than it was 20 years ago. Zellman case, Mitchell versus Helms, certainly demonstrate that. And the Establishment Clause also imposes less serious constraints on the government's ability to promote religion through its sponsorship of religious displays and symbols. Van Orden versus Perry, the Ten Commandments case, wedged open the door here, and the replacement of Justice O'Connor by Justice Alito is expected to change the law in this area even more substantially. Second, I see no sign that the courts are willing to confront the reality that church-state issues implicate multiple, overlapping, and sometimes conflicting values. When the religion clauses are taken seriously, they raise difficult questions, in part because religion crosses constitutional boundary lines. For constitutional purposes, there is a speech dimension to religion. A great many religious activities are substantially expressive in nature. Sermons, prayer, proselytizing are obvious examples. There's also an equality dimension to religion. Government preferentialism among faiths is constitutionally problematic in at least some circumstances. And of course, there's a personal autonomy and liberty interest underlying both religion clauses. But the courts haven't made much progress in reconciling these sometimes competing values or in setting out effective demarcation lines that establish, for example, where religion clause doctrine ends and freedom of speech doctrine begins. Consider the overlap of free exercise and free speech doctrine. The court has decided a long line of cases, beginning with Nootbaar versus Vincent, extending to Good News Club versus Milford, that protect expressive religious activities against discriminatory treatment that denies them access to public property. The most recent case, the Good News Club case, the court struck down restrictions that barred a club from holding religious worship services on public school property after classes had ended, while permitting secular groups to use the school's facilities for civic and educational programs. Treating religious expressive activities less favorably than secular expressive activities, the court held, was unconstitutional viewpoint discrimination. But free speech doctrine is a very harsh mistress. If it prohibits government regulations discriminating against religious expressive activities in favor of their secular counterparts, then it also prohibits government regulations discriminating in favor of religious expressive activities and against their secular counterparts. But that conclusion, I suggest, undercuts the idea that religious activities have a distinctive status for constitutional purposes. It suggests that some statutory religion-specific exemptions and accommodations that aren't available to comparable secular activities may violate the free speech clause of the First Amendment. And given the expressive nature of so many religious practices, characterizing religion as a viewpoint of speech might make a great many religious accommodations subject to constitutional challenge under the Free Speech Clause. Yet the court hasn't given us any basis or criteria for determining when religious expressive activities should be treated as speech for constitutional purposes and subject to rigorously enforced anti-discrimination principles, and when they should be treated as religion. In that case, they could be provided distinctive and sometimes preferential treatment over comparable secular activities. We'll consider the way that religious liberty and equality values sometimes conflict with each other. When government provides public funds to religious institutions for the provision of social services, those institutions claim a liberty interest in being able to discriminate on the basis of religion in hiring employees to staff these publicly supported programs. That liberty interest, however, conflicts sharply with the equality interests of religious minorities, whose employment opportunities will necessarily be limited by such discriminatory practices. Again, the court hasn't been helpful in working through how conflicting religious liberty and equality concerns could be reconciled. And it hasn't given us much help in figuring out how they could be balanced against each other either. Third, the interpretation of the Free Exercise Clause seems to be fixed and focused on two competing and fairly simplistic doctrinal formulas. One formula rejects all free exercise claims against neutral laws of general applicability. That's the Smith standard. The other formula requires the application of strict scrutiny review to justify all laws that substantially burden religious practice. Are those two choices really the only options available to us? Constitutional doctrine in other areas of law isn't limited to the bare choice of either protecting a right rigorously in all cases or not protecting it at all. We don't rigorously protect freedom of speech in all cases or decline to protect it at all. We don't have one rule for all equal protection cases. Even the recently resuscitated Second Amendment wasn't interpreted to protect the right to keep and bear all arms in all circumstances as the only alternative to not protecting the right in any circumstance. But that's the way we conceptualize the free exercise right for constitutional purposes. I don't see any indication that courts are even trying to develop the kind of nuanced, complex, and sophisticated jurisprudence for the free exercise clause that exists for so many other rights. It's hard to avoid the conclusion that as a constitutional matter, we just don't take religious liberty seriously. And fourth, we've made little progress in working through the extent to which government should be permitted to influence religious beliefs and practices and the status of religious communities through its promotion of religious ideas and messages. The endorsement test is challenged as being too indeterminate and too restrictive of religion in public life. A coercion test also raises significant indeterminacy problems, and it's criticized as being too permissive of religious preferentialism. The Summum case currently before the Supreme Court probably isn't going to help us resolve this problem because it's being adjudicated on free speech rather than Establishment Clause grounds. But the issue posed by the Summum case goes to the heart of the matter. Can the state decide to sponsor and promote certain religious messages but not others? Can it say yes to a Christian denomination that wants to donate a religious display for placement on the State House grounds, but say no to other faith communities that seek to have displays expressing their beliefs presented in similarly prominent locations? Even that basic issue is still open, and the courts haven't given us good guidance as to how to resolve it. So I would describe the state of religious liberty as a constitutional matter today this way. It's a state that's shrinking in size, it's a state that has very unclear borders, and its population isn't doing the hard work necessary to create a meaningful identity for itself. That's the constitutional perspective. Let me say just a few words about religious liberty from a cultural perspective. And I agree very much with what Barry said, that most of the issues here really are on the margin, because we as a culture and a society clearly reject religious oppression, religious persecution. That may be common in many other societies. Thankfully, it isn't in ours. But let me make these two on-the-margin points about the cultural attitudes towards religious liberty. First, and this is entirely an intuitive observation on my part, I have no data to support it. I think the cases and commentary supporting an equality or neutrality-based interpretation of the Establishment Clause are becoming accepted and are influencing popular culture with regard to both the Free Exercise Clause and the Establishment Clause. That is, the idea that government is permitted or even required to subsidize religious institutions on the same terms and to the same extent that it subsidizes secular institutions is being increasingly accepted for funding purposes. But it's also undermining the principle that there's something distinctive about religious institutions that justifies treating them differently than their secular counterparts. This is particularly true when exemptions from regulation are at issue. The equality argument in funding is undercutting our cultural commitment to the principle that religious autonomy deserves special recognition and protection. Religion can't be the same as secular beliefs and institutions and different at the same time. My second point about the cultural perspectives towards religious liberty follows up on some of the comments that our moderator suggested, but I take a little bit of a different take on them. I believe the use of religious liberty arguments as a basis for opposing same-sex marriages, kind of arguments that were expressed so often in the recent campaign for Proposition 8, will have a negative impact on cultural support for religious liberty in general. I think many of these arguments were perceived, and I think correctly, as being misleading or exaggerated. In my judgment, their primacy in the Proposition 8 campaign damaged the credibility of religious liberty advocacy in general, and that is no small cost. I also suggest that it's a fundamental mistake to ground the protection of religious liberty on the denial of other people's autonomy rights. Religious liberty is predicated on the right to be different. Its underlying principle is that we don't have to accept the truth or the value of someone else's religious beliefs or practices in order to agree that those beliefs and practices deserve protection against discriminatory treatment. Followers of faiths we consider to be false may be sinners in our eyes, but we still protect their right to be free from government discrimination and coercion. I think the campaign for Proposition 8 seemed to forget these basic principles that underlie religious liberty and equality. Ultimately, I believe Proposition 8 made it much harder for people to understand that instead of being seen as inconsistent and competing values, religious liberty and gay and lesbian rights to marry should be understood to reinforce each other. Both religious individuals and gays and lesbians seek personal autonomy. They want to be able to live their lives based on who they are, not on someone else's idea of who they should be. After Proposition 8, I think it's going to be more difficult than ever to get people on both sides of this debate to recognize what I believe to be an important principle of political compromise and reconciliation, and a basic truth as well. The most effective way to persuade your neighbors to respect your needs and rights is to demonstrate that you're willing to respect their needs and rights. Thank you.
Good morning. It's a pleasure for me to be here at Pepperdine, so I thank Bob Cochran for extending the invitation. And I appreciate talking about this wonderful topic of religious liberty, although I'm honored to do it in front of an audience who includes so many people who have spent their lives working for religious liberty, including some of the stories I heard last night about how your Human Rights Institute is working in places all over the world to make sure that religious liberty really is protected. So what I thought I would do today on this broad topic is look back at the Supreme Court's case law and then at what I call public morality, I think similar to what Alan was talking about when he talked about the public culture. And in your folders, there is, for those of you who like to follow an outline or a chart, I do have an outline of the 4 stages that I'll be working through. And it takes us back through modern First Amendment law and up to where I see we are today. So I think no one here will be surprised to think that of the 4 stages that I identify in the talk, the first stage of law and religion is the famous separation of church and state model. So going back, and in the law, I think the predominant focus of those separation cases was the no aid to religion cases. So if we go back to the old Everson case, which did allow New Jersey to provide bus rides to children from parochial schools, but then after then set out a general principle that churches, like other institutions, could have public welfare, right? We don't keep churches from having police or fire protection. But that in the long line of cases after Everson, the court consistently denied aid to religious schools, and it seemed that no matter how secular the aid, no matter how many attempts the different states like Pennsylvania have made to provide secular aid to teach mathematics and to get some funding to religious schools, that over and over again the Supreme Court said no separation of church and state meant no aid to religion. You had to keep the two fields separate. And that principle carried over, I think, into the public morality sphere when you think, well, what was the view of the culture? Is that that finally what the late Richard Newhouse talked about is we had a naked public square, or if you say that separation of church and state, it means that religion is supposed to be private. And so there was a lot of emphasis in people thinking, well, what we have is we have separation of church and state, which means that the government may never fund anything to do with religion, no matter how secular. And then in the public square, we all have a public identity in which it's almost embarrassing to talk about religion. Religion is something that takes place in private, and the political and cultural sphere should mirror the separation of the law. Now, over time, of course, what happened in those line of cases, which of course were incoherent in many ways. The Establishment Clause line of cases based on no separation. Remember, you could fund books but not maps, and so leading Senator Moynihan to say, well, what about an atlas, a book of maps? And so you had to, so I'm not pretending, anticipating the next panelist, I'm not pretending that this line of cases was always coherent, but there was a long line of emphasis on separation until what gradually happened is that people began to perceive the separation as exclusive toward religion and hostile toward religion, right? That there was too much hostility to religion, and it was hostility that was keeping religion from being treated equally, so that religious citizens weren't getting the aid that was available to other citizens. And then that religious citizens, unlike secular citizens, weren't allowed to talk about their most important commitments in public, right? They always had to privatize. And that over time, that was viewed as an unfair burden on religious believers who came forward and said, wait, both on the court and in the culture, saying, we're tired of this hostility toward religion, right? Religious liberty means something greater than keeping your religion private and having a hostile court. And so what gradually happened was that the court shifted away from the separation model to the so-called neutrality model, right? Saying, well, we've got a neutrality coming out of the sense of we've got to end that hostility toward religion that the court has displayed. And so what happened in the neutrality area is that first you see the equal access cases, some of them speech cases that Alan mentioned, right? Where you say, well, now what we have to do is if the secular groups can use the public building, why can't the religious groups use the public building, right? Equal access. Let everybody, don't exclude the religious groups because they're religion. So if you've got public space, let the religious groups and the secular groups use it. You know, try to be more inclusive than the separation model was. And then you say, well, neutrality took a funny twist in the free exercise area, where you say, well, if we really want to be neutral, then isn't the law of free exercise the Smith decision that says everybody is subject to neutral laws of general applicability? And so a neutrality model says, well, you get rid of hostility, and that means treating everybody the same way. No citizen is above the law, not even a religious citizen. And so in the free exercise area, you have this kind of matching neutrality theme, right, that says, well, just as in equal access, we let everybody into the buildings, so in free exercise, we're going to hold everybody to the same standards. And so that old compelling state interest test or the special exemptions for religion, under a neutrality model, we're going to be more suspicious of those. And then what happens in the funding area is that the strict no aid to religion rule shatters, and you get to cases like the voucher case, like Zellman, where the court starts emphasizing that what really kind of breaks up the chain of government aiding religion directly, right, is to say, well, let citizens, religious and non-religious, make their choice about where they want to spend their money, right? So Use a voucher for the school that's best for your children. Use a voucher to send your children to religious school. There's no need for the hostility of the separation era. Now we try to be as inclusive of all groups as we can, trying to set a neutral standard. And what happens in the public square to match that, I think, is that instead of thinking that referring to your religion is always private, so you could talk about it with your co-religionists, but not in the public square, is that you had more and more religious voices saying, we've got to feel free to bring our religion into the public square, right? And more politicians talking about their faith or their religious commitment or refusing to be silenced or marginalized. And so the neutrality model grows out of a perceived exclusion of religion model and to attempt to say, well, if the problem of separation was hostility and exclusion, then surely the solution should be neutrality, which sounds good, right? Whichever that we be neutral. And that gets rid of the problem of discrimination against religion. And so that's stage 2. But the neutrality began to be perceived as a problem, right? And in my stage 3, I have equality or preference. But for stage 3, I'll think you can think of stage 3 as a pick your label stage, right? Because I think this is where we are now. Some of you will see it as equality. Some of you will see it as preference. Some of you might think accommodation is a better word. I think this is where we are now in terms of the competing values that both Barry and Alan have already mentioned, right? You say, well, you know, we had this thing going of neutrality, which seemed to be a correction to the separation model. But then what was wrong with neutrality? Well, first, what was wrong with neutrality is the tremendous unpopularity of the Smith free exercise decision. Because the worry was that saying that the churches and religious people were held to neutral laws of general applicability might not accommodate religion enough, right? It might not take account of the needs of religion and religious liberty. And so what you had was Congress's move post-Smith to pass the Religious Freedom Restoration Act, trying to restore strict scrutiny. And the federal Religious Freedom Restoration Act survives, and many states have passed their own state Religious Freedom Restoration Acts, right? Saying that, well, strict neutrality doesn't really work to protect the kinds of things that the real right to religious freedom. It doesn't protect a broad enough right to religious freedom. And then after you had RFRA, you had the RLUIPA, the Religious Land Use and Institutionalized Persons Act, right? In all cases, now the political branch is saying, you know, we've got to offer more protection to religion than just Smith neutral laws of general applicability. We need to get back that compelling state interest test that Alan identified a few minutes ago as, right, that's been the two choices, Smith or compelling state interest. And of course, Smith itself, the Smith precedent was unclear because Justice Scalia said it didn't overrule past cases, right? And so post-Smith, there was all this reading of, well, when do you really have strict scrutiny? How about the hybrid? If you combine the free exercise clause with another First Amendment, with another protected constitutional right, shouldn't you get some kind of strict scrutiny? And so the neutral free exercise rule of Smith was immediately challenged as saying that neutrality doesn't really protect the full range of religious liberty. It really doesn't protect religious liberty in a way that a lot of religious organizations could go along with, right? And that was why the politicians and many religious organizations pushed for legislation that would give a fuller role to religion, saying, well, we need more accommodation. And that's why I say you could call it equality, right? Neutrality didn't work because religion needs more accommodation in order to play an equal role in the public square. And then I think in the political sphere, so you have more and more talk about faith and protecting religion. And of course, with President Bush, the move to say, you know, as part of that move to neutrality or neutrality plus or equality, we now need to fund faith-based organizations. And it's at this point that then you get into the difficult issues of, are Religious Freedom Restoration Acts and direct aid to faith-based organizations and other policies that religious groups might see as promoting them to a sphere of equality, do they ever cross the line so that there's a preference for religious groups? And the prior speakers have already raised the two places where that's been most clear. And I think there's one in the public sphere, public morality area, and then one in the case law area. Now, the one in the case law area is to say, well, now what happens if we give taxpayers' money to groups that discriminate in their hiring? You know, is that bringing religious groups up to an equal level, or is that discriminatory in some way so that there's a new discrimination? And then on the public morality issue, I think it's seen in the move to some ways that President Obama has talked about his faith, and some of the ways that faith was talked about in the Proposition 8 debate. And the way I think of that is that in a very significant passage of his book, President Obama says, you know, what he thinks you need to do to be liberal is that liberals need to translate their religious ideals into public language. And so he wrote in his book that one of the reasons he opposed gay marriage was because he didn't think it was in the Bible. But you're not supposed to go around talking about the Bible as the basis for your public policy. It's more important to translate your religious beliefs into language that other citizens can share. And see, I think that those questions of funding religion, including funding discrimination on the basis of religion, and then basing policies on religion, even if it's translated over into public language, leads us to the dispute that we have now, right? This kind of tension between, well, how do you accommodate religion without really giving a preference to religion in the eyes of the non-religious citizens? And so I think we are now is at a stage where some citizens will think, well, if you put too much religion in public policy, right, we're way past the separation model. You know, we're not in the naked public square anymore. We're much more in the funding religion and having faith spoken about openly. But does doing that exclude people of different religions or of no religion at all? And so the worry is that the current stage, like the first stage, still excludes some citizens, right? And that we haven't yet found a theory, either of public morality or of law, that's really going to be able to be inclusive. And so what I say is that what we're searching for now is what I call a tolerance model. Because tolerance was really the idea behind separation of church and state. It translated into separation, and that became a strict and rigid ideal. And as Alan's pointed out, strict and rigid constitutional ideals never really work, right? You need something with more nuance and more complexity. And so what I think the courts and the public sphere is pushing for now is some kind of model that's inclusive of everyone, right? That it's not a preference for religion, that the move away from separation shouldn't get us to a preference for religion model, but should really get us to something common. And my own view of that is that what everybody has to do is start with constitutional principles instead of religious principles when they decide questions of law and morality. And that's the broad, abstract moral principle. Of course, the difficult question is then how you translate that into a new case law. And what you might need for a new case law is a new Smith and a new Everson, a kind of modified neutrality that is as inclusive as possible without falling into the exclusion of the separation model or the possible exclusion of the equality and preference model. And one of the reasons, another reason why I'm glad to be here today is that these property cases really haven't fallen very neatly into any of the categories, right? And so they raise very interesting questions about how you're going to strike the balance between accommodating the autonomy of the churches while holding everybody to some kind of non-exclusive standard. So I look forward to hearing how everybody works out those property issues for the rest of the day. Thank you.
Well, I also want to thank Bob Cochran and Pepperdine for inviting me to participate in this conference. I always enjoy coming up to Pepperdine, to tell you the truth, and I'm especially pleased to be at this conference, in part because this issue of church property disputes is one that has always baffled me, and I have never been able to figure out really how to think about that. So I'm looking forward to the later panels. I hope to, perhaps get some good instruction on that. However, our panel, as you know, is not supposed to talk about that issue per se, but is, fortunately for me, and is supposed to talk about the general state of religious liberty in the U.S. today. And if I had, and I'm going to focus a little more on the establishment side of this, and if I had to describe the condition of establishment doctrine and law, decisions today, in one word, I think my word would probably be unmoored. We do, of course, have doctrines like the Lemon test and the endorsement test, and these do provide a vocabulary, I think, and a sort of structure for arguing about these issues. But the doctrines are quite malleable. They employ elastic notions like purpose, secular, primary effect. We know that in the hands of someone like Justice Souter, the Lemon test can mean something very different than it does in the hands of, say, someone like Justice Scalia. Now, as lawyers, when we're actually litigating cases, some of you do, I don't, but there's a little choice but to try to figure out what the patterns are in which courts have used these doctrines, and I think Leslie's just done that in a very helpful way. But my claim would be that neither the doctrines nor the decisions are themselves moored to or grounded in anything we could plausibly call the Constitution, so we're somewhat adrift. So let me start with a proposition that maybe everybody would agree on, and that is that modern law and decisions are not moored to the original understanding or meaning of the Establishment Clause. In Everson against Board of Education, the Supreme Court famously gave a sort of a strict separationist interpretation of the original meaning, and advocates of that sort of view have long been, complaining that the court has long since departed from that sort of understanding of the original meaning. My own view is that Everson didn't correctly interpret the original meaning, and that the original purpose of the Establishment Clause was more jurisdictional in nature. I've argued elsewhere that the purpose was basically just to reaffirm in writing what everybody at the time agreed on, which was that matters involving establishment of religion should be left to the jurisdiction of the states, where those matters had always been and had not been transferred by the new Constitution to the national government. Now, if that's the correct understanding, then of course the Supreme Court departed from that, even in Everson, and had long since, we've long since sort of forgotten that. Justice Thomas makes sort of halting attempts to revive that, I think, but the prospects of actually reviving that interpretation seem pretty small to me. Kent Greenawalt, who will speak to us later in his recent book, has argued that the jurisdictional interpretation is mistaken, but Kent, I think, concludes that chapter still by saying, however, modern doctrine and decisions and so forth are not based on the original meaning. He says they're not distinctively unfaithful to the original meaning. The court, has departed from original meaning in lots of other areas as well. But nonetheless, original meaning isn't governing things here. Of course, if we define the original meaning at a lofty enough level of generality to mean something like government should do right by religion, or government should behave justly in matters of religion, then we can say we respect the original meaning, but of course then it's not constraining or guiding us in any way. Well, if the modern law is not moored to the original meaning, it might be moored to something a little broader, like the American political tradition. And in fact, some decisions do rest quite heavily on this. A few do. Waltz against Tax Commission, the tax exemption case, Marsh against Chambers, the legislative prayer case, did stress quite heavily the American political tradition. But most decisions don't do that, I think. And on the contrary, I would suggest that they exist at best in a state of uneasy tension with the American political tradition. Realistically, the question in modern law is not so much whether the justices and doctrines are guided by the tradition, but rather how far they're willing to go in subverting or repudiating the tradition. This is most apparent, I think, with the endorsement doctrine that's since about the mid-'80s, seems to have been accepted by the courts. The doctrine says that government should not do or say things that send a message endorsing religion. Now, In fact, those sorts of statements and endorsements are a vital part, I would suggest, of the American political tradition, including some of the most cherished aspects of it, from Jefferson's Virginia Bill for Religious Freedom, Almighty God hath created the mind free, and so forth, to the Declaration of Independence, talking about the Creator endowing us with rights, to state constitutions, I think every one of which contains some sort of statement of deference or thankfulness to Almighty God or the Supreme Being in some form or another, to the national motto, In God We Trust, to the Pledge of Allegiance that says that we are one nation under God, to inaugural addresses given by every president of the United States, from Washington to Jefferson to Lincoln to now President Obama. If the endorsement doctrine were faithfully implemented, all of these expressions would presumably be suspect or perhaps unconstitutional. A week ago, I happened to be in Washington, and I only make it out there, it seems like, about every other year. And when I do, if I have time, I usually like to walk over to the Lincoln Memorial, sort of my favorite place there, I guess. So I did, and read Lincoln's powerful second inaugural address that's inscribed on the wall. If the endorsement doctrine were faithfully implemented, perhaps that would need to be sandblasted off, because it's thoroughly, profoundly religious from beginning to end. Apologists for the doctrine sometimes try to excuse some of these expressions by saying that they're private expressions. You know, the presidents are speaking as individuals when they give inaugural addresses. This strikes me as a rather implausible account. I think we generally assume that the presidents, when they give the inaugural address, are speaking to us as president. But it's typical of the kind of interpretations, very strained, I think, interpretations that supporters of the endorsement test are often forced to give of things, for example, like the words under God in the Pledge of Allegiance. I think Justice O'Connor's explanation of how those words don't really send a message endorsing religion today, you know, convince almost no one. I think actually demean the law in this respect, but they do serve as a way in which the law can grudgingly defer to tradition, and it sometimes does. But it's virtually never, I think, grounded in or actually animated or inspired by the American political tradition. Well, I think that the law also has departed, and this in a way is the more important point, I think, from not just from the American political tradition, but more importantly from the broader Western tradition. And here I'm going to have to try and summarize really briefly an argument I've tried to make at considerable length elsewhere. So let me try and do it this way. We often think of non-establishment or church-state separation as an American innovation, and in some sense, perhaps it has been, but in a larger sense, this is a commitment with very ancient roots, I think. Church-state separation arises, I would argue, from basically a Christian worldview and a kind of moderate Christian dualism in which the world is seen as, and life are seen as divided into two realms, the spiritual and the temporal, or the spiritual and the secular. So Christian authors have always talked about the two cities, the two swords, the two kingdoms, and so forth to convey this idea of dualism. However, this is not a radical or like Manichaean dualism. It's not a sort of light, dark, good, evil understanding of the world. In the Christian view, both realms are subject to God's will. Both are good, in a sense, and both make their valid claims upon us. We're supposed to render unto Caesar the things that be Caesar's, and unto God the things that are God's. So we can see this idea, for example, in the Lord's Prayer, or the Our Father, that Christians have recited over the centuries. Thy will be done in earth as it is in heaven. Two realms are distinguished here, but both are subject to God's will, to God's overarching truth. Now, the hard question, of course, that arises then is, what is God's and what is Caesar's? Or institutionally translated, what is the church's? What belongs to the jurisdiction of the church? And what belongs to the jurisdiction of the state? And our commitment to church-state separation, I think, arises out of this kind of dualism. And in the medieval period, for example, this gave rise to some epic struggles. We remember Thomas More going to the scaffold for refusing to acknowledge that Henry VIII could be the king, the Lord, the ruler of the church, so forth. Or a few centuries earlier, Thomas Becket being murdered in Canterbury Cathedral, basically as a result of quarrels with Henry II over the jurisdiction of the church courts. An even perhaps more seminal struggle was that in the 11th century between the Emperor Henry IV and the Pope Gregory VII. very colorful story. Gregor was attempting to assert the freedom of the church and to free it to some degree from secular control. Henry was defending the ruler's traditional prerogative to have a hand in the appointment of bishops. The conflict escalated. Gregory ended up excommunicating and essentially deposing Henry, and this was an effective measure in this case because some of Henry's nobles then refused to support him. Losing power, Henry was forced to travel to the castle up in the Alps in Canossa, where the Pope was staying, wait barefoot and ragged in the snow for 3 days, pleading for forgiveness, which the Pope eventually felt moved to grant. Henry thereupon, of course, returned to his empire, consolidated his power, got an army, and drove the Pope out of Rome and installed his own Pope. But this was a case in which you see these two jurisdictions attempting to establish their separate jurisdictions. Now, in this classical context, I think debates about these matters had two salient features. One is church-state separation was viewed as a jurisdictional problem. In that sense, it was comparable to the kinds of problems we might talk about today in, say, federal courts or constitutional law classes, the relation between states or the states and the national government or the federal and state courts. What are their separate jurisdictions? And it was debated largely in religious terms, in terms of the overarching religious truths that were assumed to govern both realms, so that both popes and kings appealed to scripture, natural theology, canon law, writings of church fathers, and so forth. Over the centuries, obviously, different writers and rulers gave many different answers to these sorts of questions and took many different positions. But these two salient features, I would suggest, continue even into our own founding period, so that Madison's Memorial and Remonstrance, famously written in support of religious freedom in Virginia, gives as its primary rationale a very overtly theological rationale for religious freedom and explains it in jurisdictional terms. Jefferson's Virginia Bill, I've already quoted, Almighty God hath created the mind free, coercions in matters of religion are a departure from the plan of the holy author of our religion, who being Lord both of body and mind chose not to propagate it by coercions on either, and so forth. A very overtly theological justifications for religious freedom. Today, though, there's been, I think, a sort of inversion or transformation, so that today the secular is understood basically to mean not, as Nomi Stolzenberg says it classically meant, a specialized area of God's domain, but rather simply not religious. So that we could say the state was and is a secular institution, but once that meant acting in a specialized area of God's domain. By now, it means something like the state is supposed to be not religious, not to act for religious purposes, but for secular purposes. And with this transformation, then, we get a kind of inversion of the classical problem. The problem of jurisdiction recedes in favor of a problem of justice, we might say. Now the state has jurisdiction. It determines how much scope to give to religious freedom, but it should act justly, of course, and so we try to figure out what justice means. And that question will be debated mostly in secular terms, of course, not in religious terms. But now, with this inversion, I think an urgent question arises, and Alan actually has said quite a bit about this already. The question is, why should religion be a special category at all? If what we have is the problem of justice, and if religious believers and associations are just one category of citizens and associations among many, all of whom deserve to be treated as justice requires, what is it about religion that requires any sort of distinctive treatment? That's a question that has often gone unnoticed, but it's always been in the background of our discussions, and I think it increasingly becomes a conspicuous one. Scholars and judges have tried to answer that question, and all I can say in very conclusory ways is that they, or we, I think, as I try to contribute to this as well at times, have probably not come up with any very powerful answers. And as a result, there's a tendency, which Alan described, I think, to increasingly reduce church-state commitments into other commitments that are more at home in a secular world, like free speech or equality. Alan's sort of written, I think, somewhat persuasively against this in places, and appeared to regret it today, though I would just suggest, and this would take us off, that his remarks on same-sex marriage and religion basically did that by suggesting, that individual autonomy is the value that it's at the core of all of this, and that should apply to religion, but to other issues as well, where it arises. Just to try to sum up, then, I think we've inherited some assumptions in the text of the Constitution and culturally that we have a commitment to treating religion and religious freedom as a distinctive kind of commitment. But on prevailing assumptions, it's also hard to explain why it should be. Unmoored from their historical roots, our commitments to religious freedom tend to lose their reason for being and their sense, and become unmoored and become somewhat adrift. The result of that, I believe, is that, in fact, our church-state decisions are driven not by anything that could plausibly be described as the Constitution, either the textual Constitution or what we might think of as constitutive traditions, but rather by the opinions, preferences, predilections, prejudices of a legal elite. Now, when we're lucky, that elite is prudent, respectful, even wise. When we're less lucky, the elite may be self-confident and imperious. Moreover, I think an important qualification here that we're fortunate, I think, to have a legal elite that mostly seems to believe that it's not supposed to rule just in accordance with its own predilections, but rather to act in accordance with something called the Constitution. It may be that upon closer investigation, we in the elite can give no intelligible account of what that even means, but nonetheless, the assumption may still serve as a valuable constraint on the proclivities of elites just to impose their own, in their view, enlightened notions on the rest of us. For that, those of us who are not in sync with that elite can at least be thankful. Thank you.
Well, thank you for all of those marvelous talks. I believe, Bob, you want to go to our panel of experts first for questions for the moderator. Professor Greenawalt.
Well, I wanted to say a couple of brief things about Steve's presentation. I only thought his view was mistaken in leaving out some effect on the federal government. I thought what his position on leaving jurisdiction to the states, I didn't disagree with that. So we understand. I didn't think your view was as mistaken as you implied. There was a lot of approving laughter when you talked about private speech, and I think that's a much more complicated issue. I think we've got private speech, we've got government speech, and then we've got something that's in between, which is speech by somebody who's a member of the government making a speech, but which might have more latitude than, let's say, a statute or a majority judicial opinion. So I think that's a more serious issue about that. The other thing I wanted to raise a question about or make a comment about, but I'm very interested in responses, is the gay rights and religious liberty thing. Barry, you seem to suggest that there was a clash across the board here, huge clashes, and
potential.
Yes, you seem to suggest there was no clash at all if all this was properly understood.
The way I recommend it to be understood.
Yes. So I thought that, look, the Catholic Church doesn't have to recognize marriages that are recognized civilly and so on. So I think the worry that the churches are going to have to recognize, that seems to me, maybe down the line 300 years from now, that's a worry, but I'm not worried about that right now. I thought the issue where it does come up seriously is, if the government is funding some activity like an adoption agency or a school and so on, so the activity is being carried on largely with public money, but it's a church group that's operating it, what is going to have to be the hiring policy for the people that are working in that activity? And my understanding is that this was a strong disagreement between President Bush and the majority of Congress, and defeated the legislation that Bush that he wanted to get through, so he issued an executive order. But it seems to me there is a serious clash, and conflict that needs to be resolved. And there may be other areas, but that's at least one where I think there's a realistic conflict.
I agree. I think there will be some conflict areas, and I think we should resolve them the way we resolve other conflict areas that arise. When we enacted Title VII and decided we were going to prohibit religious discrimination in hiring, we created an accommodation for religious organizations. We didn't say we're not going to prohibit religious discrimination in hiring across the board. We used the tried and true methodology of seeing exactly where the conflict was and trying to work out an accommodation that best expressed our commitment to multiple values. And I think we should try to do that whenever it's reasonably possible to do. I don't think you solve the problem by telling gays and lesbians they can't get married, because that will lead to certain potential conflicts which can't be resolved politically or appropriately, and therefore we have to take the extraordinary position of not permitting a group to exercise the basic right to marry. So, yeah, same thing with protecting women against discrimination in hiring. That was going to create some conflicts with the religious tenets of religious groups and organizations. We didn't decide we would protect women against discrimination. We'd work out appropriate compromises. And I fully support those kinds of accommodations. I just think to say that you can't prohibit discrimination across the board because of those potential conflicts, or you'll deny people the right to marry because there will be those potential conflicts, is really exaggerating the degree of conflict, and it's ignoring the way we've dealt with those problems throughout our history. This isn't new. And anti-discrimination regulations and other important public policies will sometimes cause problems for religious groups. We have a military today, notwithstanding the fact that it burdens pacifist faiths, but we do give them conscientious objector status, try to compromise, and do our best to maximize competing values. And that's what I would like to see happen in the area of protecting gays and lesbians against discrimination and permitting same-sex marriages.
And in support of that model of accommodation, take the issue of political belief. In the federal government, at least, you have the division between career civil service employees and political appointees. You could see that as a kind of accommodation for, whether a belief should be given effect and whether there should be no discrimination based on the basis of political beliefs.
Yeah. I mean, my model is, you hear analogies made between gays and lesbians and blacks. I think that's the inappropriate model. I think the good model is gays and lesbians as Jews. And if you think about gays and lesbians as being a religious minority, well, all kinds of protections exist for religious minorities. We also accommodate religious organizations when we allow them to discriminate on the basis of religion with regard to a lot of their decisions.
Professor Smith?
Well, just a couple of comments. Alan and I had, very brief exchanges on this, I think, and so forth. I sort of agree and with him to an extent, but only to an extent. Alan, I think, is, as, some time back, I recall reading an essay that Alan wrote on this, advocating this accommodation model and so forth. So, I mean, he's, I think, an earnest supporter of this. There's still sort of two dimensions, however, I'm troubled. I think Alan is more sanguine about the possibility of a really satisfactory accommodation than I am, for various reasons. But one he mentioned just now, where he said, well, the analogy to race is not the appropriate analogy. It's not that I disagree with that, but I do think that many, many people believe it is the appropriate analogy or something like it is and are quite passionately committed to that view. Insofar as that's true, it seems to me that the receptivity to the kinds of accommodations that Alan would favor is just not likely to be nearly as great as he hopes, and that means that accordingly the concerns on the other side of the issue are much more realistic, I think, and genuine than perhaps he has allowed. The other, in some ways, more primary consideration just is, though, assume you could make all of the accommodations of that sort that anybody would want. And so you can just focus on the primary issue of, same-sex marriage. I heard Alan basically to say, well, then it becomes just a question of a commitment to individual autonomy. And this would actually tie into Leslie, perhaps. I mean, you didn't say, I think, anything specifically about this issue. But when Leslie, at the end of her remarks, said we should be resolving questions more on constitutional rather than religious principles. So you get a big question there about to what extent any of the religious values and commitments are appropriately relied upon, even in addressing the primary question, something Kent has written 2 books at least about, I think, and so forth. But all I would say is I am skeptical that it can really be reduced either to rely on constitutional principles or rely on individual autonomy as the way of resolving those kinds of questions. I think they're much more complicated than that. So those are just 2 grounds of reservation about what was said there.
Well, and may I say on that point of interpreting the Constitution, whenever I say that, I get a response similar to Steve's, is that people worry, well, the Constitution is so indeterminate, right? It doesn't give us clear answers. But my point is only it gives us different answers because it's a different tradition from religious traditions. And so it's not that oh, we turned to the Constitution and now we have the easy answer. But it's that the discussion, like if we have the discussion on, is gay marriage like race? Is it like Jewish? Is it being like a woman? Is it, we think we understand these because we can fit these into equal protection categories. And we start and say, let's have a discussion about what equal protection means within the Constitution. And I'm pretty certain that that is a different discussion than one that starts with what the Bible says about gays or women or Jews or what religious traditions have said. And so it's not that you switch to the Constitution and now, voila, we've got a quick and easy determinate answer. But I still think that arguing within traditions is different, right? We all know because we're lawyers, like arguing in California is now, I know since arguing in California is different from arguing in Texas. You know, you have different law, different principles. And so in the same way, starting with the kind of common constitutional argument is different from starting with a lot of religious principles. And I think that's the worry that I have about the gay marriage debate or the religious hiring debate, that in the move away from the don't talk about religion, we shifted to talking a lot about religious principles as the first principles.
Yes, sir.
You all have not raised one issue that has been very much of concern, and that has to do with abortion and with when life begins, and some of the changes that are occurring now in terms of beginning to say that people can decide they cannot even participate in distribution of contraception, all the things related to that. To what degree is the state moving in the direction of being the one who's going to determine when life begins, which is as theological and religious a question as there can be?
Thank you for that. And I also wanted to follow up with Kent and say that is an area of actual conflict right now, especially the North Coast case in the contraceptive cases. Where people are declining to exercise or provide medical services on the basis of their religious beliefs, and so I will put that to our panel of experts.
I don't have an answer to that question, but since you mentioned the North Coast case, are you all familiar with the North Coast case, generally speaking?
Summarize.
Yeah, it was a case where physicians refused to provide artificial insemination services to a lesbian patient, and she brought suit under the UNRU Act, the California Anti-Discrimination Act, and the case went up to the California Supreme Court. California Supreme Court has never interpreted our state constitution with regard to the meaning of the Free Exercise Clause since Smith was decided. So for 18 years, we don't know whether the California Constitution follows Smith or not. And one of the reasons we don't know is because the California Supreme Court, when cases come before, it says, well, even if we applied strict scrutiny, as some petitioners are suggesting, the religious liberty arguments aren't sufficiently powerful to outweigh the compelling state interests that are on the other side. So it always ducks the issue by minimizing the application of strict scrutiny review. And it certainly did that in the North Coast case, where the analysis of strict scrutiny was trivial, even though it was arguendo. But I co-authored an amicus brief in this case, arguing that the court should apply strict scrutiny to the physician's arguments. It should take the physician's religious concerns about participating in this activity seriously. But I also thought that there was a compromise. I always think there's a compromise, and that the physician's position was hard to accept in the context in which it was asserted. And my problem was that the patient wasn't informed that the physicians weren't going to go forward with the treatment until they'd already disclosed an awful lot of personal information to the physician and had been in the course of being provided medical treatment. And I wrote a statement on Find Law and said basically, it's too late once the patient bears body and soul to the physician for the physician to say at that point, oh, and by the way, I won't continue treatment. because now I recognize you're asking me to do something that offends my religious convictions. I think physicians who want to be protected against providing certain services have to make it clear to the patients in the waiting room or even earlier so that people can make a fair choice as to whether or not they want to go to this particular physician for treatment, and they won't be subjected to the kind of embarrassment and emotional distress that the patients experienced in that case. Now, people might not agree with my particular compromise, but I do think there are often ways to resolve these disputes in a way that demonstrates to both sides that you're respecting their important concerns. And I don't think we pay enough attention to that possibility. I certainly agree with Steve that there will be some conflicts that are not easily resolved. But why don't we resolve the ones where we can achieve compromise and then really struggle with the ones where somebody's really going to have to accept some significant loss in their rights?
I might just say, your question, I think, in general, insofar as I understand it to be asking about these questions about, you know, a doctor or a pharmacist, or, you know, who, in case of abortion or something similar to that, has a religious objection to supplying medication or performing a procedure or whatever, raises, I think, very much this question that, in a way, all of us have talked about. You know, so what we're after here, some sort of government that simply is kind of neutral in the sense that it tries to treat religion no differently than anything else. Or is it supposed to, is there some claim to accommodation because the objection is religious? That's the one that I guess I suggested that we're sort of in a quandary over, because on prevailing assumptions, it's not clear why there should be any special reason to treat the religious objection any differently than any other. Now, sometimes people in courts will try to get past that by saying, well, what will accommodate then is not the religious objection, but something a little broader than that, like, you know, a deep-seated moral objection or a conscientious objection of some kind. And that can seem to avoid the problem of giving a special favor to religion. But then, of course, you still ideally would want some justification, you know, for why whatever you know, I think conscience is, that, you know, what it is and why it should be treated differently. And I have actually tried to write some things justifying that, but I'm not sure whether mine or other efforts along these lines that I've seen really work. So, I mean, I think we're sort of in some doubt about that.
And on your specific question of abortion, when you said that it's a religious and theological matter, I guess what I would have to say is it is, but has to be resolved as a legal matter, right? And again, that doesn't settle everything, right? But if I say, well, what should the law of abortion be? Well, ensoulment, for example, is not the starting point of the debate. People with deep religious convictions come to the debate and then need to argue about it on constitutional grounds. And of course, I think part of what happened is that what was perceived is that there was either, quote, secular humanism or utilitarianism that was kind of the philosophy driving so many of the decisions on abortion and other issues, right? And if that's so, then the response is to say, wait, we don't want our society ruled by Bentham or anybody, you know, we don't want a utilitarian or purely secular meaning, if you interpret secular as anti-religious interpretation of the Constitution. And so once you have that debate and say, well, when I say, oh, you have to start your argument based on the Constitution, I mean that for all of the philosophers and atheists and secularists as well, right? That nobody is supposed to say, well, my starting point for abortion is that life is meaningless, because that's my atheistic philosophy or agnostic philosophy, and that's equally bad a starting point too. My starting point on abortion is that life is sacred from the moment of conception. Those are all grounds, of course, for individuals to make decisions about whether to have abortion or not. But I think the hope that I still have is that starting with the constitutional argument is a different argument.
Well, if I were the judge, what would I do then if I were told I'm supposed to interpret, you know, the right of privacy or whatever the right is, you know, due process clause or whatever, but don't rely on utilitarianism, don't rely on your religious belief, don't rely, you know, What would I do?
Well, I mean, but then we do what you're back to, right? Then we really have to have a serious discussion about original understanding or original meaning and what the 14th Amendment means. Do we? And I think even within traditions, right? I mean, we all know the tools that you bring to traditions, and you say, well, do you want to read a text only with its original meaning, or do you interpret it through the history, right? We know what those kind of standard arguments are. And again, they're not always completely satisfying, but you say, well, we've got the history of the country, we've got what the framers said, we've got the text of the Constitution, and then you have an argue about it. It's not always satisfactory, but the good faith starting point is to try to engage your fellow citizens with that starting point. And then to explain, I mean, and I think the important thing is, I mean, for those of you who know it, I'm sorry, at this point I'm just parroting a low-level version of John Rawls and political liberalism. I think then the thing is, you don't have to kind of go around hiding that you're religious or saying, I'm never going to talk about my religious convictions, but that you try to see past wanting your religious convictions to be the law for everybody.
Okay, let me open it up to the whole entire audience for questions. And yes?
Mic up here. Thank you. Thank you very much. Can everyone hear me? I have a question primarily for Professor Brownstein, but also for anyone on the panel. And that was, during your presentation, you talked about the equality principle and how at some level this is actually undermining what's distinctive about religion. And this has been a concern for a long time, that if you don't maintain some sort of separation between church and state, religion itself might lose its prophetic voice or its ability to critique the government. And this goes back to even Adam Smith, of course, who famously argued economically that by maintaining a separation between church and state, the churches themselves would be stronger. So I want to turn this around on the Prop 8 issue, which the panel began with. And as I understand it, one of the key issues with Prop 8 that's so interesting is that prior to the California Supreme Court's decision, gays and lesbians in California already had civil union rights that were legally equal to marriage. But the issue was marriage itself, and whether or not having that term applied to those civil unions was an equal protection violation. One of the things that some traditional marriage defenders have talked about is the idea of removing marriage from the civil public square and making it only a religious thing, so that everyone would have civil unions but never civil marriages. And my question for the panel is that it seems to me that if that happened, marriage would become truly and only a religious thing. And it would mean the churches themselves would have to start teaching more about what marriage means, and marriage would gain a greater religious significance in society than it does today. So my question is, if we were to remove marriage from the public square, would we avoid the issue, Professor Brownstein, that you have highlighted of this battle between people of faith and gays and lesbians that may not be healthy for a liberal society, and at the same time somehow strengthen the church itself?
It's not going to happen. So, it gets raised as a hypothetical, but I don't know anyone who seriously thinks there's potential for society to accept that, for relegating marriage exclusively to religious institutions. But my other point is, I think it's a drastic step to take to deal with this kind of problem. I think the problem is more complicated than just the term marriage, I should say, because although within California, gays and lesbians receive virtually the same benefits as heterosexual couples through the civil union status. Under federal law, gay and lesbian unions aren't recognized at all because of DOMA. So there are a great many material inequalities that exist. And a lot of people think the only way to successfully challenge DOMA is to recognize gay and lesbian same-sex marriages, because if you have a patch quilt of civil unions that means something different in every state, you're never going to get federal recognition of same-sex marriages. So there's an instrumental issue there as well. But But there are an awful lot of issues where it's very important to be able to claim the terminology, and religious groups may have particular perspectives as to how that terminology should be applied. And let me give you the most obvious example. Religious groups have some sense of what's a religion and what isn't. So let's assume this hypothetical. The government says, we're going to protect a particular belief system. It could be Judaism, it could be Church of Latter-day Saints, it could be Catholicism. And we're going to give you the same protection that we extend to recognized religions. But we're not going to identify you as a religion. You're a belief system and nothing more. Would people find that offensive to the allegedly religious group who was relegated to belief system status and was denied the identity of being a religion, even if you had the same status? So I think this problem can arise in a lot of different situations, and because of that, I'm not very supportive of the idea of transforming the nature of marriage to solve this problem, because basically I think we have to confront it politically and in a way that respects the values that are on both sides of the issue.
Mark?
To go back to what Professor Griffin had to say about talking about these things in constitutional terms, if your constitutional approach, at least a part of it, is original meaning, and you find, as Professor Smith has pointed out, that original meaning is religious, then you're in a bit of a quandary, aren't you?
Right. Well, but that's when I say that you don't have to adopt original meaning as a constitutional theory, right? That you say that our understanding of what the 14th Amendment did or how we view religion now. Part of the issue is, I think the question lurking here that I thought Alan was going to mention when you were talking about a separate belief system is that it's not that easy to define religion anymore, right? Like kind of in the background is a religion, and religion is going to be accommodated. But I think part of what's gotten us away from being able to apply original meaning easily is to say, well, we don't have a population that's anything like the original population.
But God hath made the mind free. I mean, that's pretty religious. And the idea that we would, from an establishment clause, which we might initially think our best approach is original meaning, we would then somehow interpret it to mean that we can't use original meaning because original meaning would tell us that it means something we don't want it to mean. That's vicious circularity, I think.
Well, I think I'd say that a lot of people, I think, would say the original meaning was to have tolerance or to kind of end the wars of religion, and so that even on original meaning grounds, you don't have to come to a religious reading of the Constitution, right?
Except that the basis for the tolerance very largely was a religious understanding of the world, but maybe I've made my point.
Could I add something?
Sure.
I don't believe in the original understanding, so that's an easy issue for me. But if I did, I think we confront the issue, and I think Steve mentioned this, that it's a question of the level of generality that you use to understand original meaning, which is a perplexing problem, but we do all the time with equal protection in a lot of areas. So if I was going to argue about the meaning of the Establishment Clause from an original meaning perspective, I'd say maybe it's true we used religion to justify the protection that we assign to religion in the Constitution, but the religious principles that we used were the broadest and most inclusive that we could understand at that time. Very, very few non-Christians who were recognized as people. We didn't count Native Americans as having religious sensibilities that needed respect at that time. So you could look at the general original understanding as using religion, but only at its most general and inclusive manner. And the problem we confront today is we have such a diverse society that it is very, very hard to identify a religious foundation that is truly and meaningfully inclusive. That's a problem.
If I may ask a question, I'm neither a law professor or a law student. I'm but a humble practitioner. But at the risk of disclosing my own level of analysis, let me offer this question. If some preference or accommodation is to be made to religious-based viewpoint, if for no other reason than it is singled out in the Constitution, separate from the free speech clause, as deserving of protection, what happens, and I think Professor Griffin, you alluded to this, what happens if religion is then defined or redefined to mean anything? And courts are precluded from inquiring as to the sincerity or centrality of one's view, or even if it's shared by others. Doesn't that result in a kind of a radical autonomy that you were talking about, Professor Brownstein, and wouldn't that have a very balkanizing effect on society at large?
You want me to take that?
Whichever. Both.
I was thinking we need, but hasn't Kurt Lash written about that? What does equal protection do to free exercise, right? Do you look back and say, well, we tend now to read things so much in an equality sense and saying that, well, if we've got equal protection in the 14th Amendment, doesn't that prevent us in some way from treating religion in a way that we would have without the 14th Amendment? You know, if you carry over the equality theme from the 14th Amendment, it might modify what kind of preferences and accommodations you can give to religion.
If I understand your question, you're saying if we provide privileged and distinctive protection to religion, and we don't really have a foundational understanding of what religion is, then anybody could assert that their beliefs and interests are religious and could demand that level of privilege and protection. And then we have Scalia's radical anarchy, which was one of the justifications for Employment Division versus Smith. Have I understood the argument correctly? I'm a pragmatist in my response to this, and I do a lot of lobbying for religious liberty legislation, and I'm always asked, what about the Church of Chardonnay? What about some made-up sham religion who's going to demand that we extend privileges to them? And we all know this is not a legitimate religious commitment or belief. The problem is that no society that protects religious liberty, no Western democracy at least, has an effective operational working definition of what religion is. Yet most of them do what we do, which is to say they respect religion as a distinctive interest, and they do try to accommodate diverse religious beliefs. So notwithstanding that possibility that on the margin there will be some cases where people assert a religious belief and receive an accommodation and don't really deserve it, in the vast majority of cases, it's not an issue. I mean, apparently there are cultural consequences for claiming that going to the 49ers game is your religion, and so you want an accommodation, so you don't have to work whenever there's a conflict between your job and attending a football game. People look at you funny and become offended, and your boss thinks you're a less valuable employee even if you get the accommodation. So the reality is, it just doesn't happen very often, and it would be a shame to throw out all of these very legitimate claims for exemption and accommodation from recognized faiths because of that possibility that occasionally somebody's going to sneak under the wire and claim a benefit that they don't really deserve.
Well, that's why I called stage 3 equality or preference, because for the groups who don't get in, they're going to see those accommodations as religion's getting something that they can't, and therefore unfair. And that's why I mentioned equal protection earlier, right? If so much of our perspective, our cultural perspective, is affected by equality, and you see, well, wait, there are certain religions that will identify and respect, but I can't be one of them, then you set up the worry about what one side sees as equality and accommodation, the other side sees as preference.
I've thought about this as well and have been surprised, right, it was initially that you don't have more kind of sham religions going in and making these kinds of claims. And maybe Professor Brownstein is right that it's the social pressure that keeps people from doing that. But I think it almost might be a fear on people's part that there really is a God and he might not like this very much.
But there are a lot of prisoners cases. There are a lot of prisoners.
Well, maybe they don't have much to lose but in this life, but I would remind them. Well, we probably better cut it off. I saw maybe a few more hands, but maybe you can raise some questions with our speakers down front or privately, but we do need to move along with our schedule.